So it's 4 o'clock, and I want to welcome everybody, all participants, to this workshop on with the title Pacemaker Brussels ? Which is organized jointly by the Leibniz Institute for Financial Research, SAFE, and the Center of Advanced Studies LawFin at Goethe University. I am the scientific director of SAFE, so I myself am a financial economist, and I have been here at the department for long years trying to help developing a culture where law and finance, law and economists talk to each other. So all these institutional names that we just mentioned in some way have been developed and created here in Frankfurt. And I'm really proud that this culture of discussing legal aspects in economics and economic aspects in law gets momentum. And I see this workshop as part of that story. Of course, I'm not a lawyer, of course, so I'm not into the details of what you are discussing, but taking it from an economist's viewpoint, I think this workshop looks at the role played by regulatory rules in a competitive environment, both as being subjected to competition, as being part of defining the competitive process. And that's what makes the discussion of rules and maybe the competition of different rules so exciting for economists who always think in competitive terms, in competitive outcomes. And for a long time, when I thought about competition in legal rules, I immediately associated race to the bottom. So if you have regulatory rules and there's competition among rule makers, then the rules will evaporate because of the pressure of markets. And this, in a way, is so that's my understanding, at least, that's a bit short-sighted or a short view of things, because if you have this race to the bottom, there are reactions by rule makers to this development that may actually change the dynamics quite a bit. And we may even see race to the top as an alternative explanatory hypothesis for what one sees in real life if one looks at regulatory systems as competing with each other. So one area where this is interesting to observe is the standard setting. For instance, think about sustainability standards, which are currently being heavily discussed worldwide, and there's a lot of competition. If you think about climate change as a major policy dimension, how do you measure climate or climate change? And that competition is fiercely carried out in basically vis-a-vis capital markets who want to invest their money, and they are searching for criteria. And the new institution, International Sustainability Standards Board, which is going to come to Frankfurt, offers an opportunity, I think, for all of us to study how such rules will emerge and how the competition among standard setters or would-be standard setters really looks and will be lived out and works. And I hope that we are part in one way or the other of that process. Data privacy legislation is a different field, but I think is subject to the same competitive pressures. And I have, of course, followed in the public debate the idea that Europe will push ahead and create a completely new economic ecosystem around strict privacy laws. And of course, I'm very eager now to hear what you as researchers have to say about privacy rules and their role in a competitive process. But of course, I don't want to say anything in terms of content about your talks. I leave this to Katja Langenbucher, who together with Tobias Troeger have designed this workshop, and I'm very grateful for their effort. And I hand over to Katja to introduce into the real thing of today's workshop, the papers and the discussion. Thank you for your attention.
Thank you so much, Jan, and welcome everyone. I'm really happy that Tobias and I can host this first workshop, first as in first for the Law Lab associated with the Leibniz Institute SAFE, together with Tobias's SAFE-LawFin Institute. I'm really excited about the workshop because from the lawyer's perspective, as Jan pointed out, that there's different perspectives, so I need to take the law perspective. Have long been interested in understanding what's called, be it the California effect, if you're looking at it from the US perspective, be it the Brussels effect for those who have started to export that type of thinking to especially the GDPR, but also other parts of regulation, in order to understand to what extent it's only a claim or it's actually happening, that Brussels is setting standards in many ways. And so I thought it would be a really interesting idea to contrast these two papers, which seem, at least to me, to come at least to somewhat different conclusions, and we'll learn more about whether they actually do, and also to what extent this might go back to different methodologies used. So just to quickly introduce our speakers, we will first hear from Stefan Bechtold, who's a professor of IP law at ETH Zurich, and he's been working on IP, but also on internet and privacy and telecommunications issues, as well as antitrust law and technology and law and economics. He's also a member of the academic advisory board of the German Federal Ministry for Economic Affairs and Energy, and he's a board member of the Society for Empirical Legal Studies, which works especially well with our outlook in Frankfurt, as well as an advisor to the copyright project of the American Law Institute. And Stefan holds a PhD from Tübingen and a JSM degree from Stanford, and he's been a visiting professor all over the place, for example, at NYU, at Haifa, and he was a senior research fellow, sort of as Frankenreiter at the Max Planck Institute for Research on Collective Goods. And he has been in Amsterdam, and Berkeley, and Chicago, and Munich, and Singapore. So we're really happy to have him with us, even if it's only virtual. Now, our second speaker today is going to be Jens Frankenreiter, who is right now a visiting professor at the Washington University in St. Louis School of Law. And he's been working on business law, contract law, and comparative law, and also fits in really well into our interests in Frankfurt, because his work draws on methods from economics, statistics, and data science to improve our understanding of said areas of the law. And I'm particularly excited because he's been working on big data, which is something I have been working on. Also, he holds the PhD from the ETH Zurich and a Master of Law from Harvard Law School. And before coming to Washington University, he was, as I mentioned, a senior research at the same Max Planck Institute in Bonn. He also was a visiting associate professor at Virginia School of Law and a postdoc at the Milstein Center for Global Markets and Corporate Ownership. Our discussants today are Tobias Troeger, who is, of course, with the Leibniz Institute SAFE, and also with the LawFin Institute and with Goethe University more generally. We have a second discussant, Bian, who's from UBC Sauder School of Business, and Nicolas Jabko is from Johns Hopkins University. So much, so good. Really interesting speakers, really interesting discussants. So I'm very much looking forward to that. And I won't say much more. And Stefan, the floor is yours.
Great. Thanks a lot for the kind introduction. Let me just share my screen. All right. So thanks a lot, Katja, for this very kind introduction. I wanted to thank the organizers, in particular Katja Langenbucher and Tobias Troeger, for setting this up. I think it is a great idea to couple these two presentations, because we're looking at a question empirically using very different data sets, and we can come to somewhat different conclusions. It's also a special treat for me because Jens is a former PhD student of mine, and I've been very proud of what he's achieved in the meantime. Now, I must say that the paper which Jens is going to present was not part of his PhD, and so if you're ultimately not convinced of that paper, this was not due to any errors I made, I think, in the supervision, but probably something later happened when Jens moved on. Now, Jens is much better educated and smarter than I am, and so you may understand the pressure that I feel to win this debate today. So I'm trying to do my best to convince you that I'm right and that Jens is wrong. And so in that spirit, I was wondering, when looking at the announcement of this workshop, whether a very neutral announcement as this is the proper format, or whether we should actually envision a more kind of competitive debate between Jens and myself about whether there is something as the Brussels effect. And so let's see how we'll fare. So the background was already introduced, so I don't want to spend a lot of time on this. Increasingly, in lots of areas in business law, not only privacy, but also other areas of the law, you see extraterritorial application of the law, which can lead to situations where there's competition between countries to become a global rule maker and a leader in that competition. And very prominently, Anna Bradford, who's now at Columbia, issued first several law review papers and then later a book on the Brussels effect, making the argument that in various areas of European Union law, the EU has succeeded in exporting some of its rules and regulatory approaches. And one of these areas, she argued, is privacy. Now, this is, of course, ultimately a conceptual debate, but it has an empirical angle, because the question is, whether this effect that Anna Bradford argued exists, whether you can actually also see this in real life. And so what both Jens's paper and the paper I'm involved in is about is an approach to use quantitative methods to get at this. So the paper I'm involved in, and I just want to show this to pay proper tribute to my co-authors. It's a paper involving Christian Peukert, who is also among us today, Michail Batikas from Rennes School of Business, and Tobias Kretschmer from LMU Munich. So the paper that I'm going to present is broader than what I'm going to focus on today, because we're interested in various questions in the paper. We use the GDPR as a testbed to investigate questions like, what's the compliance level with the GDPR? What are the effects of the GDPR outside the EU, and what are the effects of the GDPR on market structure and competition? And so if you just want to get the 30-second elevator pitch of the findings of our paper, this is the overview. So we are interested in, or we track basically over 100,000 websites before and after the GDPR was introduced. And we are looking at various effects. So we are looking at what happens to so-called third-party domain requests on websites before and after the GDPR. And we find that these third-party domain requests decrease after the GDPR. And for our purposes, what's particularly interesting is that this effect to some extent can also be observed when you look at websites that are legally not required to obey the GDPR because they are located outside the EU and do not cater to an EU audience. And so this is where this Brussels effect story comes in. We're also looking at other issues in the paper. For example, we're interested in whether compliance differs between large and small websites. We are interested in whether the data minimization goal of the GDPR has been achieved, in the sense that cookies are or less cookies are placed on the browsers of individual users, which we find. Then we're interested in the changes in the competitive landscape. So we find that in the markets for web technologies, the dominant firm, Google, can increase its market share after the GDPR. The market overall shrinks, but the dominant firm loses to a lesser extent compared to its competitors. And so from our perspective, this paper has various implications, and we're interested in the unintended consequences privacy regulations have on market structure and competition, and also on this debate whether the European Union has succeeded in shaping global privacy rules beyond the European Union. What I'm going to do today is I'm going to focus basically only on this GDPR and Brussels effect story, so I won't talk about the other aspects of the paper. Few words about the GDPR. I don't think I need a full introduction here. It's the most important regulatory framework in the European Union on privacy, and most arguably perhaps even worldwide. It came into force in 2018. What is important for our kind of empirical setup are a few legal components. So the GDPR drastically increased the sanctions regime compared to the data protection directive that existed before. Nowadays, companies that violate GDPR can be fined up to 4% of the global turnover. And this is similar to antitrust risks in the European Union nowadays. There's a strong consent requirement, so lots of things, not everything, but lots of things under GDPR require consumer consent. There is a joint responsibility regime, which is for our purposes important. So websites that rely on third-party technology providers cannot easily dispose of liability risks by outsourcing, because the websites which are data controllers may also be liable for privacy violations that are done by data processors. And so this leads to liability risks for websites under the GDPR. Now, for our purposes today, most importantly is the territorial scope of the GDPR. The GDPR applies in lots of cases. First, kind of there are standard cases. So the standard case is a case where the website that offers its website or some service on the internet is located in the European Union, and it's catering to an EU audience. This is clear that the GDPR applies. Now, if the website is located in the European Union, but the audience primarily is located outside the European Union, the GDPR still applies. The GDPR also applies in the reverse case, that the website is located outside the European Union, but it caters to a EU audience. The only case where legally the GDPR does not apply is when the website is located outside the European Union and the audience which this website is targeting is also located outside the European Union. Then the GDPR does not apply. But Anna Bradford has raised the question whether, due to the Brussels effect, de facto websites are obeying the GDPR. And so de facto, there could be an extraterritorial effect of the GDPR. And so that's what we are after. We are basically, in that part of the paper, we're ultimately interested in this lower right cell. So what are we doing? We are interested in websites and web technology providers. And so I just want to give you a short kind of intuition of what we're after. For those of you who are not that familiar with how this works. So if you go, for example, on the New York Times website, your browser will contact newyorktimes.com, but will actually fetch lots of content and so-called third-party trackers and cookies from other websites, from other domain names, and integrate them into the website that you actually are seeing. And so this is from just a screenshot from an earlier paper that shows that if you go to the New York Times homepage, you are actually exposed to 61 third-party domains, because this is where all little pieces of the website are compiled together. And the way this works is that if you look at the HTML code of a website, there will be lots of these third-party requests, which are basically then other URLs, which then the browser executes and then collects and then combines this into a website. And so what we are doing in this paper is basically analyzing the HTML code of lots of websites before and after the GDPR, and we're interested in whether the amount or the type of these third-party requests, which also include cookies but are not only cookies, whether this changes over time. So where do we get the data from? So we look at about 110,000 websites across many categories, and we're interested in these so-called HTTP requests. So these are the requests that the New York Times website will issue to a third-party domain. And this can be, advertising, content delivery related technology requests. It can also be cookies. So the way how we get at this is we look at an archive, which is publicly available, which is called the HTTP archive. This is a bit like the Wayback Machine, which some of you may know. So this is a service that scrapes, tons of websites on a regular basis every 2 weeks and archives the websites. But unlike the Wayback Machine, the HTTP archive archives these third-party domain requests. So we can basically look at the New York Times webpage, in 2017 on March 1st, see, all right, it created these 61 third-party domain requests, and then we look at the same webpage half a year later, and we can observe whether it's the same 61 third-party domain requests that were created, or different, or smaller, or a higher amount of requests. We also use data that enables us to identify the location of websites. We use Whois, the Whois registry database and Crunchbase. And we are interested also in identifying, what the target audience of a website is. We use different measures. So we use the language of the website, which particularly works for non-English language websites. We look at top-level domains. So if there's a domain which is .de or .fr, this is an indication that this is targeting towards Germany or France. And we look at rankings of websites on a country base from Alexa, where we get information, what websites are popular among German or French or Dutch or so consumers. And so just to give you an intuition about how the last issue works, if you think about the NewYorkTimes.com web site, according to the Alexa ranking, this is the top 30 website in the United States. It's the top 208 website in the UK, and so on. You see the numbers here. If you look at Boston Globe, it's the top 1,200 whatever website in the States, but it's not among the rankings of Alexa for UK, France, Italy, or German customers. So there are differences when it comes to international websites, to what extent they're accessed by foreign consumers, and that's something we explore. So, in the interest of time, I want to give you a snapshot of the results as far as they relate to the Brussels effect. So what we look at here is the number of third-party domain requests. So this is, this exercise where we, trace a website before and after the GDPR was introduced, and look at, just the number of third-party domain requests this website issues. And this is arguably, some measure of the response to the GDPR, because lots of these third-party domain requests will, be about privacy-sensitive information. And so a rule that increases privacy protection should decrease the number of third-party domain requests that are issued by website. And we do this in the newer version of the paper, in accordance with this matrix, which you saw before, where we split our observations according to whether the website is located in the EU and whether it's targeting consumers in the EU or not. And so you see for the standard case, an about -8% decrease in the number of third-party domain requests around the time when the GDPR was introduced. This also holds for other cases when the website is located in the European Union, but the audience is not, or when the audience is located in the European Union, but the websites are not. And interestingly, we also see an effect, although arguably smaller, but statistically significant, for websites that are both located outside the EU and that target consumers outside the EU. And so arguably, this can be interpreted as a sign of a potential Brussels effect. So we do several other things in the paper. For example, we then split our observations and say we're not interested in domain requests per se, but we're interested in cookies, because arguably cookies are more consistently privacy sensitive than the more general category of third-party domain requests. And so if you look at cookies per se, the effects are basically in the same direction. They are just stronger. And so we see about a decrease by about 3% in the number of cookies that are set by websites that are located outside the European Union and are targeting consumers outside the European Union. Now, of course, there are lots of issues about how to measure these things. How do you identify whether a website is located within or outside the European Union? How do you determine whether a website targets consumers outside or inside the European Union? Ultimately, if this was a matter in front of a court would have to decide these issues on an individual basis. Now, we can't do this. We're looking at 100,000 websites at the same time. And so we use some proxies, but in an appendix, we basically we do various robustness checks in order to make sure that our results do not depend on particular specifications on how we identify websites, whether they are located or targeted within the EU or not the EU. And so I'm happy to talk about this more in the Q&A. We have different measures for both location and targeting of the audience, and we combine them in various combinations. And we're pretty confident that the results which we present in the main part of the paper are actually the most conservative way to measure this, and we may actually measure the size of our effects. Now, of course, this is for us. This is an indication that there is a Brussels effect taking place, although only to a certain extent in our data. There may be various reasons why you can observe the Brussels effect. Companies may decide to apply the GDPR to all consumers worldwide because of cost or reputation issues. They may expect that other countries will adopt GDPR-like regulations, and so they are basically faster and want to, in the future, have the same rules across the globe. They may preempt other countries to adopt GDPR-like regulations. They may just, decrease the political pressure in some countries in order by basically complying voluntarily with the GDPR. So there are various stories that you can come up with why, that can justify the results that you just saw. But of course, empirically identifying these reasons is beyond the scope of our project. We can just speculate about what's happened. So let me just conclude. There are, as with any of these studies, there are some limitations. I'm just mentioning a few of them. We're looking primarily at short-run effects, although on the cookies, we're pretty sure that this has a longer term that we see. There are legal issues, like, we look at the introduction of the GDPR at the EU level. We're not going into the national member states' enforcement and privacy laws that may be masked by the GDPR. There are issues about causal identification in a study like this. There's an entire cottage industry of GDPR papers nowadays that use similar measures than ours, and all of these papers suffer in one way or the other from the problem there is no perfect control group. Now, we are still rather confident that our estimates, are getting close to a causal estimate, but formally, this is not kind of a totally clean causal identification. There are some policy implications of our study, which I don't want to go into right now. I just want to mention that this discussion is not only, of course, about the GDPR, but there could be similar effects with the California Consumer Privacy Act, with the e-privacy regulation that's coming up, with the Artificial Intelligence Act, with the Digital Markets Act, with the Digital Services Act, which all share similar features. And with this, I want to thank you, and I'm looking forward to Jens's presentation. Thanks.
Thank you so much, Stefan. I like the way you set up the debate, and we're looking forward to Jens entering the ring right now.
Okay, terrific. So first of all, thank you so much for the opportunity to speak here today. I appreciate the opportunity to present this paper, and I'm particularly excited to do so together with Stefan, who is my former PhD supervisor, and also because I'm really excited about both papers. I guess Stefan has dealt the first blow. Now, I guess I'm in a position to stage a counterattack. I think this is not an easy task because I think that Stefan's paper is really excellent. However, what I'm going to try to do is convince you that their paper only shows part of the story that's going on, and that the real story is a bit more complicated. In other words, I think that the answer to the question whether a California effect exists in the area of data privacy law is not a simple yes or no. What that also means, on a more conciliatory note, is that Stefan and I might seem to disagree on the surface, but I really think that the two papers together convey a way better picture about what the California effect really is than any existing account in the literature. Okay, so let's get started. I want to start this presentation by saying what this paper is about and what it's not about. You all know already that this is an empirical investigation of the existence of California effects in data privacy law that are connected to the entry into force of the GDPR. So a very similar focus like the one of Stefan's paper. However, I think it makes sense to be a bit clearer about what exactly that means in the context of my paper. And I think it's particularly helpful to be clear about that, to see how the two papers that are being presented here today interact with each other. First of all, different from Stefan's paper, my paper focuses primarily on transactions between US online services and US consumers. By contrast, I don't really talk about whether the GDPR spills over into other jurisdictions as well. The scope of Stefan's paper, as I understand it, is a bit broader than mine, but I don't think that this difference matters that much. Second, like Stefan's paper, I'm interested in a particular kind of California or Brussels effect. If you read the literature on these effects, authors mean all kinds of things when they use these terms. David Vogel, for example, who is usually credited with coining the term California effects, mostly talked about a political economy story where companies active abroad started lobbying their home legislators to adopt similar regulatory standards to the ones that they encountered abroad. One example is German automobile manufacturers that face strict regulatory standards in their operations in California, going back home and starting to lobbying EU legislators and German legislators to adopt higher emission standards as well. By contrast, I, like Stefan, am mostly interested in some kind of like unilateral effects of regulation. By that, I mean instances in which companies active in more than one jurisdiction start applying the most stringent standard they encounter anywhere in other jurisdictions as well, without the legislator there adopting similar regulatory standards. Anne Bradford, in her work, calls these effects de facto as opposed to de jure Brussels effects. Different from Stefan, I tried to paint an even more fine-grained picture by trying to distinguish between different mechanisms that can cause such unilateral effects. And in particular, I'm interested in whether such effects can come about in data privacy law as a consequence of the fact that it can be costly for online services to treat consumers in different jurisdictions differently. This is what I call, in my paper, cost-based California effects. Finally, my investigation focuses on privacy policies. In other words, I don't try to measure how companies actually treat consumer data. I try to understand what promises they make in their privacy policies and how these promises change over the entry into force of the GDPR. A particular focus on my investigation is on whether companies give consumers notice about their rights as data subjects under the GDPR, for example, the right to be forgotten. The fact that I focus on data policies, privacy policies, as opposed to privacy practices is, in my opinion, the most important difference between our papers. In a way, our papers focus on different dimensions of GDPR compliance. The fact that we, spoiler alert, find seemingly contradictory results might point to the possibility that California effects or Brussels effects cause companies to treat consumers everywhere alike on some dimensions, those where differentiation is relatively costly, while they don't do so on every dimension, those where it is relatively easy to treat consumers differently. Okay, so much for what this paper is about. I want to continue by providing some more motivation for the paper I am presenting today. A large part of the literature on data privacy law assumes that the GDPR affect how multinational companies treat consumers worldwide. Exhibit A for this theory are decisions by big online companies like Google and Facebook, who in spring 2018 announced that they would change their data practices to bring them in line with the GDPR. And importantly, changes, and with them changes in the privacy policies of these companies, were announced not only in Europe, where Google and Facebook, as Stefan mentioned, are under a legal obligation to comply with the GDPR, but also in the US, where the GDPR does not apply, at least not for businesses operating out of the US themselves. Why would companies like Google and Facebook do that? One common explanation for these effects assumes that it is costly for businesses to treat consumers in different jurisdictions differently, and therefore for trans-jurisdictional actors, it can make sense to treat consumers everywhere according to the most stringent standards that they face in any jurisdiction. This is exactly what I mean by cost-based California effects. The claim that cost-based California effects are at play here is exemplified by this quote from Anu Bradford's new book. For digital companies, she writes, maintaining different data practices across global markets is often both difficult and costly, leading them to treat everyone in accordance with EU data privacy law. But as the second side shows down here, she's not alone in thinking that this is what's happening. At the same time, especially before Stefan's paper came around, there was not a lot of empirical evidence that would support these claims. And today, there's little work that would try to distinguish between cost-based California effects, what these authors mentioned, and other forms of cross-jurisdictional influence. The first move that I make in the paper is to argue that it makes sense to differentiate between these different mechanisms. I think that there are two main reasons for that. For one, the normative implications of cost-based California effects are different from those of other forms of cross-jurisdictional influence. In a nutshell, cost-based California effects imply that trans-jurisdictional businesses sometimes offer products around the world that are more protective of consumer interest and also more expensive than consumers in at least some jurisdictions like. Other forms of cross-jurisdictional influence are different in that regard. For example, if adherence with higher standards allows providers to signal superior quality or something like that, they will only produce such high-quality products in other jurisdictions and provide them there if this decision is justified by consumer demand there. Second, the mechanisms at play also have an impact on when we should expect firms to apply European data privacy law worldwide. Most importantly, if costs of differentiation are behind Google's and Facebook's decisions, we should expect a similar behavior for most firms out there. And finally, if cost-based California effects are at play here, it seems at least plausible to assume that transactions between online service providers and consumers on the internet might be affected by the laws of other jurisdictions more general. This is something that Stefan also mentioned. Think consumer contract law or other legal areas. In other words, these effects, if they are driven by cost-based California effects, are very likely not limited to data privacy law. What my paper does is investigate these claims empirically. Before I show you my results, I want to talk briefly about the empirical approach I use in my paper. I got interested in these questions sometime in 2017 and decided to start gathering some data, back then together with Johann Herrnstruber at Max Planck in Bonn. To investigate these effects, in principle, I need information on whether companies other than Facebook and Google also changed the way they treated consumer data across jurisdictions. However, data practices, the way companies treat consumer data are hard or impossible to observe, especially if you're not as smart as Stefan and his co-authors, who came up with the genius idea of looking at the use of third-party services. Therefore, what I did with my limited means, I decided to focus on privacy policies instead. Privacy policies, as most of you know, are descriptions of the data practices of online services and the rights that individuals enjoy in their relationship with the particular service. For reasons that I'm happy to explain in more detail in the Q&A, these policies are de facto mandatory in all jurisdictions. But are these policies a good measure of companies' privacy practices? Well, in the end, it's hard to know. And of course, the study ignores a lot of the potential dimensions on which one could potentially observe California effects. The one that Stefan talked about is a good example. But I think that independent of how you think about this, there is an interesting lesson that can be learned from privacy policies. Why is that? Well, as I said before, what many authors cite as evidence for the existence of California effects, of Brussels effects, is the decisions of just a few big online services to adopt globally GDPR-compliant privacy policies in the wake of the entry into force of the GDPR. Even if you think that privacy policies don't tell us much about what companies actually do on the ground, at least my paper can be seen as a test for the question whether the decisions of these firms, Google and Facebook, are paradigmatic of what most firms did, or whether these firms are exceptions. In other words, if nothing else, I can at least measure the existence of a very specific version of the California effect, which also happens to be the version of the effect that is usually described in the literature as typical for the California effect. Okay, so what did I do to obtain the data? In late 2017, I started downloading privacy policies on a weekly basis, using VPN clients to make sure I know the privacy policies that were shown to consumers in different jurisdictions. I amended the data set later on, and today it contains the privacy policies of around 700 online services. The most important part of the data set is the one that you see in the first bullet point here. I have the privacy policies from the biggest 500 websites in the US as per the Alexa ranking maintained by Amazon. Besides, I have what one can call a control group, although I use that term only in quotes, and I want to make sure I'm very clear about that, because I don't think one can infer too much from direct comparisons between these two groups. More on that later. As I said, I gathered these privacy policies on a weekly basis. The data set that I get can therefore be compared to a panel data set with a balanced panel structure, an N of around 700 and a T of around 100. In my analysis, I use various measures to track how websites reacted to the entry into force of the GDPR. Now, if you make some simple back of the envelope calculations, you will note that the number of privacy policies that I'm looking at here is pretty high. Overall, we're talking roughly about 70,000 policies. So how do you make sense of that? In a first step, I analyze these policies using a range of what I call computational techniques. Put very simply, I use natural language processing and similar techniques to develop a range of measures that allow me to track how privacy policies change over time. The advantage of these measures is that I can calculate them for all policies in the data set. But of course, a computational analysis can only go so far. Therefore, I also manually read and coded, again together with Johan Hermstruber, a pretty large subsample of policies to see whether the contents of these policies confirm the results from my computational analysis. This is the part of the analysis that focuses mostly on privacy rights. What do I find? Here are just some of the most important results. First, I find, in a way like Stefan, that the GDPR impacted privacy policies everywhere, not only in Europe, but also in the US. The graph on this slide is the, sorry, I'm seeing the chat. The graph on this slide shows the length of privacy policies over time. The x-axis shows the date, the y-axis is the length of privacy policies, measured in number of words. The upper panel shows US privacy policies, and on the lower panel, I show EU privacy policies. What we see in this graph is that the length of privacy policies takes a pretty steep turn upwards at the time of the entry into force, which is depicted here as a dashed black line. This uptick, importantly, also the one in the US, is so dramatic when compared to other changes that occurred during the time window at which I'm looking, that it could not possibly be explained by chance. So the GDPR seems to have affected not only interactions between involving EU consumers, but also interactions between US online services and US consumers. At the same time, what we also see is that the changes are bigger for EU websites than they are for US websites. This is important because it points to the possibility that although US services change the privacy policies they show to US consumers, these consumers were not granted the full protections mandated by the GDPR after all. Now, if you remember what I said when I talked about the two samples, it can be problematic to compare them. This is because they potentially include websites with different characteristics. But there are a number of services that appear in both samples. What do I mean by that? One example of that is WhatsApp. WhatsApp has an American website as well as a German website. WhatsApp used the same privacy policy on both websites until May 2018. After that, it created a separate, more protective privacy policy that applied exclusively to consumers in the EU. This slide shows a comparison of the increases in length for the privacy policies for websites that appear both in the US sample and in the EU sample between April 2018 and July 2018. Let's stop for a moment and think about what we're doing here. I'm comparing two groups of privacy policies. The first consists of privacy policies used in transactions between US online services and US customers. The second group consists of privacy policies used by the same US services, but in transactions with EU customers. What the setup allows me to do is to test the hypothesis that the GDPR affects transactions involving EU consumers differently from transactions involving US consumers. If cost-based California effects force all US online services with operations in Europe, where they're subject to the GDPR, to treat everyone in line with this regulation, we would expect the privacy policies used in different versions of a website to change in roughly similar ways. In the graph, they should be clustered around the diagonal line that runs from the bottom left to the top right. Those that don't change at all in the bottom left don't change at all in both versions of the website. Those that change a lot in the EU version of their website should also change a lot in the US version. Instead, what we see here is that policies in the EU sample have grown at a substantially higher share, at a substantially higher rate than the corresponding privacy policies that were shown to US consumers. Roughly half the matched policies in the sample increased the text of their EU privacy policy by at least 5 percentage points more than the corresponding US policy. This is a pretty strong indication that most services do not treat EU consumers and US consumers alike, as the California effect would predict. But this analysis does, of course, not answer the question how exactly the GDPR affected transactions between US online services and their consumers in the US. I think ultimately that the strongest evidence comes from my manual coding of privacy policies. I coded 150 randomly selected US websites at 2 points in time, April 2018 and October 2018. The coding scheme that I use captures how many of a number of specific requirements in the GDPR were implemented in the policy. One example of such a requirement is the famous right to be forgotten. Importantly, this right, as well as other rights, have to be described in a service's privacy policy if the service wants to be in compliance with the GDPR. Based on these individual measures, I calculate a score that captures the amount of protection offered to consumers, or in other words, the extent to which a website's privacy policy complies with the GDPR. When coding these websites, I stumbled upon a lot of privacy policies that look like the one on this slide. This is a part of the new privacy policy that Pinterest adopted in May 2018. Actually, most part of the privacy policy was just left unchanged. But Pinterest did make one major change. They included a new section that had special rights that applied exclusively for consumers in the European Economic Area. Bear in mind that we're looking at the US version of Pinterest's website here. If you were logging onto this website from somewhere in the EU, the privacy policy announced that you would be treated in line with the GDPR. But if you were in the US, you did not profit from these protections. For these reasons, what I did is calculate two different scores. One captures the amount of protection offered to US consumers, the other one the amount of protection offered to EU consumers. In case of Pinterest policy, the score for EU consumers would be, after the change, relatively high. The score for US consumers relatively low, and probably just unchanged from before the entry into force of the GDPR. Okay, so let's see how standards of protection changed overall. This slide shows you two histograms. As you can see, the histogram on the left shows the level of protection in April 2018, the one on the right, those in October 2018. In both histograms, the dark gray bars show the level of protection offered to US consumers. The light gray bars show the level of protection offered to EU consumers visiting the same websites. The further to the right you get on each of these histograms, the higher the level of protection offered to consumers. Now, as you see in April 2018, most websites do not offer GDPR-style protections to their visitors. This is true both for visitors from the EU and for visitors from the US. It's also not terribly surprising because the GDPR only entered into force in May of the same year. However, the picture is completely different in October 2018. In October 2018, 52 of the 150 US websites offered substantial protections to EU consumers. However, only 10, that is less than 20%, offered similar levels of protection to US consumers. This finding confirms what we had suspected earlier. Most US online services treat US consumers and EU consumers differently. It also indicates that a lot of the changes observed for US privacy policies do not in any way profit US consumers. Instead, what many websites seem to have done is amend their privacy policies in a way that grants additional rights to EU consumers, but leaves the status of US consumers untouched. In the paper, I also run a couple of regressions to see what predicts global compliance. I find that it is mostly big and very visible websites that become globally GDPR compliant, plus websites that cater to certain adult interests and dating websites. So where does this leave us? First of all, Google and Facebook, those companies often cited as paradigmatic examples of the Brussels effect, are exceptions and not the rule. Many services changed their privacy policies around the entry into force of the GDPR, but only a small minority promises to treat US consumers and EU consumers the same. Instead, what most services do is implement a more or less GDPR compliant regime for EU consumers, but find ways to ensure that these standards do not apply to US consumers. Again, what I observe is mostly the promises companies make to data subjects in their privacy policies, and in particular, whether they promise to grant consumers the various rights mandated in the GDPR. It is absolutely possible that there are other dimensions on which most companies treat consumers in all jurisdictions the same. Stefan's paper. Still, in my opinion, these results seem hard to square with explanations that point to costs of differentiation as the main cause of the global adoption of GDPR-compliant privacy policies by companies like Google and Facebook. If services that are way less sophisticated than Google and Facebook are able to treat consumers in different jurisdictions differently, why would that not be possible for what might be the most teched up and sophisticated firms on the planet? Instead, the finding that adult entertainment and dating sites are much more likely than others to comply with the GDPR everywhere points to the possibility that demand-related factors might be a main driver of these effects. I think overall these findings, especially viewed when together with Stefan's, paint a richer story of California or Brussels effects than the one that you often find in the literature. These effects do not always imply that one jurisdiction unilaterally imposes its rules on other jurisdictions. Instead, there are instances in which what is commonly discussed as California effects is really driven by demand for higher standards. And I want to add one thing. This is in no means meant to diminish in any way the big contributions that Anu Bradford and others in the field made to the literature. The fact that Anu Bradford came out with these theories in the first place and showed us in all the different settings in which they applied really provided the ground on which people like me can now run these kind of studies. So I'm indebted beyond measure to her really seminal contributions. I'm happy to talk about all that in more detail during the Q&A. For the moment, I want to leave it at that, and I'm very much looking forward to your comments and questions. Thank you all very much.
Thank you so much, Jens. And we have 3 discussants lined up now before we can go into the Q&A sessions. So, Tobias.
Yeah, thanks. One empirical takeaway immediately is that law review articles are significantly longer than finance papers, and particularly so because Stefan's paper actually combines 2 papers. Let me just use my discussion to get rid of this idea of a combat fight here between the 2 and take a more parsimonious approach. Also because I'm not really willing to get into this. I'm too old for these kind of fights. So I think that both studies essentially find something that is compatible, because the setup of the studies is exactly the same. The GDPR, the arrival of this regulatory intervention, is treated as an exogenous shock. And then both papers look at different dependent variables in order to determine the effect of this regulatory change. And one is the number of third-party requests, the other one is the changes to privacy policy. And the interesting thing is that both papers definitely find observable, albeit less incisive effects compared to directly affected websites. And therefore, I think much of the interpretation that Jens has just shown hinges on the fact that he says, okay, it's not equal treatment, but that is not necessarily associated with the Brussels effect. So there's a pull, right? So people are more or less benefiting from protection that they should not be afforded due to legal reasons, but there are other mechanisms. And Jens particularly investigates a cost-based California effect. So if it's really the cost of a discriminating compliance for European customers on the one side and a different policy vis-a-vis US customers on the other side that drives this. And there he finds very negative evidence. But definitely the paper also acknowledges that other mechanisms may be at play. And if you recall, essentially Stefan's paper was agnostic vis-a-vis the mechanisms that are at play. What I find as something that I could say to both papers is I find it a little bit puzzling that you're not saying much about the economic significance of the estimated effects, particularly Jens' paper. You're mentioning that Google and Facebook have a quite strong adoption of their privacy policies, and therefore these are important market players, and I would be interested in how much of the market is actually affected in economic terms, because if the compliance comes from many midget firms, I'm less interested than the fact that maybe many the larger firms are compliant. Now let me just turn to Stefan's paper a little bit. Using the key output variable like real-time interactions across entities, the HTTP requests raises for me the question, because I'm not technologically very experienced in this field, whether there's a qualitative difference beyond the cookie example that you're using, because cookies obviously are very incisive with regard to privacy issues, but there could be another way of looking at this, because you're also looking at categories of services, and also the survey privacy policy suggests there are differences in what you actually request as a third-party provider of these websites. And you observe a market concentration in the second part of the paper, and the lower number of requests may well stem from the simple observation that more service providers offer broader services, in the sense that you can gather more individual data with one request. And I'm not sure if this is technologically what's going on, or if it's at least a possibility of that. Second, let me just question whether it's really a Brussels effect, in the sense that it's the regulation that drives the whole thing. There could be something else going on. And one thing that I was thinking about is a simple scale effect story. So if you're developing the third-party services, then of course you're also, and you're mentioning that in your paper, implying that there are economies of scale of work. So if you are essentially building a service that somehow has to serve the GDPR requirements, but it serves your client's interest well, it is something you would sacrifice, essentially cost efficiency considerations, by designing another service as the third party. And therefore, one way of looking at this could also be that it's simply a technological scale effect that drives the results, and not so much the Brussels effect in the classical sense, but it's really that you design something that is GDPR conforming and you sell it across the world, and then most or a couple of firms simply have to adopt this. And the second, I think, more fundamental point here is it really that somehow relates to the design of your sample and your survey period in particular? You're showing, and that also already has popped up in the chat, a temporary effect. And this may well be that it has nothing to do with the Brussels effect or with the GDPR as such, but with the legal uncertainties that you described very well in your paper regarding the introduction of the GDPR. So if I'm a firm that is not entirely sure whether I'm covered by the GDPR, I might simply reduce the potentially incriminated activity until the dust settles and I know more about whether I'm covered or not. And also, the second aspect, I think, speaks a little bit into this direction, because you're showing that obviously the larger providers of third-party services gain market share, and that also could be read as, you know, these are those suppliers of services who can offer probably GDPR conforming services because they have access to better resources, legal advice, etc. And also because they have deep pockets, because if something goes wrong, they might be those who are actually helping you out with liability. And both, in fact, would arguably be temporary and not a steady state effect. And therefore, I would be interested, you know, if you intend to extend this survey. Let me skip this one because some stupid organizer gave us 7 minutes for the discussion. With regard to Jens' paper, I was wondering how good a predictor your privacy policy variable really is with regard to actual privacy policy practices, because you know, even if you assume that the websites adhere to the policy that they put out there, the privacy policy essentially defines an upper bound for data processing. It is quite plausible that the leeway that this privacy policy would afford you is not fully exploited in practice. So what you're measuring might be even an underestimation of the effect that we see. And therefore, I think that also for that reason, some of your findings are actually consistent with what Stefan is looking at. Therefore, you know, this could be addressed, I think, you know, at least a little bit more explicitly in the paper, and that would help. Then the second point that I want to raise in my very brief discussion is you have a quantitative task for the global that you described very well, and you also described the reasons why you actually choose these two websites or the operators of websites that have two distinct EU and US privacy policies. But these are the ones that obviously discriminate, right? So there might be a selection bias because I think the extreme version, and I'm not sure, you're not saying anything in the paper if that exists or if that is something that is just dreamt up. In theory, the extreme version could be that there is a global form of compliance by simply having one document that really has no qualifications whatsoever. And we see that in securities, in the securities space, for example, in derivatives trading, you have master agreements which are applied all over the world. And therefore, there is this uniformity across the world and the global standard. I would be interested in if anything of that sort exists and how you actually address the question of selection bias. And last point that I want to make, you're looking at the determinants of global compliance, and what you're using is the fraction of EU users that frequent one website or the number of visitors of the website in total. And the last essentially is a proxy for the size of the website. But I was wondering why you are not looking at firm characteristics of the entities that actually operate the websites, because you're rightly saying in the beginning that the California effect essentially, you know, the cost-based California effect kicks in when the compliance costs are lower than the cost of discrimination. And both of these cost factors essentially are possible to distribute among the customer base. So both the compliance cost and the cost of discrimination. You're discussing the distribution of these costs among customer base of a website operator only with regard to the cost of discrimination. But I think it's really something that you can do as well for the cost of compliance. And therefore, I think it matters a lot how the firm that actually operates the website and the service that they provide and the pricing of the product that they are marketing through the website, how that actually that this actually matters. And so this is something where I would really like to see more data. I have a couple of more points which I also skip, and I will send you my comments later. So this is from my side. Thank you.
Thank you so much, Tobias. I know we're all rushing us through to get some time for discussion. So Bo, if you want to continue with your critiques and discussion points.
Yes, so I first want to thank the organizers for having me to discuss those two very interesting papers. I really read the papers with great interest and wanting to understand what are really happening, how to reconcile the results of the paper. So I'm going to focus on 2 points here. First of all, I'm going to talk about more the empirical differences between those two papers and why do they come at slightly different conclusions. And then, how should we think about putting the papers together and think about, the different factors driving the different results. And then the second point I'm going to talk about is increasingly fuzzy geographic boundaries in the digital world, especially with the transition from websites to mobile apps. And in this new world, how should we think about regulatory spillover? How should we think about the optimal level of regulation even? All right. So regarding the first comment I have, I want to start from 3 different points, interpretation of the result, measurement, and also sample. Most importantly, I think this is already mentioned by Tobias, that the interpretation seems to be the key reason driving, the set of papers reaching slightly different conclusions. So in the first paper, in Stefan's paper, they find some effects for the technically untreated group and use that as evidence of regulatory spillover. And if you take a look at the table, you can see kind of the relative magnitude of the results across the 4 different groups. So you can see that for the non-EU and non-EU audience group, this coefficient here, minus 0.02, is smaller, but still significant change compared to websites located, in EU, serving EU audience, or the other 2 set of also kind of a technically treated group. And as I mentioned, this is interpreted as evidence for regulatory spillover. But based on the coefficients, if you compare this one and this one, you would interpret that 70% there is 70% lower effective treatment when compared with the fully kind of more treated EU to EU group. Even if we compare this coefficient with the non-EU firm to the EU audience group, you still see 50% lower effective treatment. So if we interpret this, more at the extensive margin, it means that maybe 70% or 50% of firms are less firms, fewer firms are being treated with this technically non-EU firm, non-EU audience untreated group. And let's move on to Jen's paper, which is about the heterogeneous treatment effect for EU and US customers. So those are kind of 2 important figures which Jen's already presented in his part. And you can see that the first one, there isn't, perfect one-to-one mapping between EU and US in privacy policy changes. But if you look at the dots, it seems that the majority of the dots still, are located around this 45-degree line, which means that there is some positive correlation between the changes at least. And in the right figure here, you can see that the mass of the distribution, indeed, both of them are for the EU consumers and the US consumers, the mass of the distribution moved to the right when we, move from April to October, basically before and after GDPR. And of the 70 websites that increase privacy protection, 52, which is 75% around, treated EU consumers favorably. If we kind of interpret it in a similar language I mentioned before, it means that around 75 a lower effective treatment compared with the US-EU group. So previously in the first paper, we are talking about 50 to 70%. So this is not kind of a big change compared with a big difference compared with the first paper. And then, the outcome measures are also different, which is kind of important here because the outcome measures directly speak to the trade-off around compliance, which naturally lead to differences in the spillover effect. And the other point I want to mention is about sample selection. So in the second paper, it is looking at US websites, kind of to study spillover. It is looking at US websites serving US customers, while in the first paper, they are studying non-EU websites serving non-EU customers. So second, the data set in the first paper, or I should say, the sample used to study spillover is much wider compared with the first paper. So it could be that compared with the second paper, sorry. So it could be that the US market is large and unique, which provide the developers with more incentive, the firms with more incentive to develop products, including tailored privacy policies to cater to this market. So to this end, basically the sample selection, which will determine the relative size of the EU market to the non-EU market, will be proportional to the spillover effect. So again, this difference can also partially account for the fact that the two papers observe slightly different effects. So what I want to conclude here is that the two papers offer similarly opposing findings, but I would rather interpret this as different readings from the heterogeneous spillover effect across firms, across websites based on the different outcome measures and different set of treatment and control groups based on different samples. And note that the language being used in both papers are kind of conservative in the sense that the first paper was hinting a Brussels effect, and second paper was talking about limited effect at best. But both of those are quite qualitative and quite a subjective assessment. And if we think more about the measures being used in the paper, one is more kind of about what firms say, right? The privacy policies is about what firms say, and the use of third-party cookies and all that, it is about what firms do. And I do think that what firms say and what firms do are all very important. Probably what firms say is more important to accountants, to regulation, disclosure regulation, and what firms do is more of interest to economists. And but it's important that we understand both what firms say and what firms do around regulatory changes. And ultimately, one important question here, I think this speaks to the different results and the ultimate goal of the assessment of those policies is how much compliance should be expected for the untraded firms, for the untraded websites, and what determines a compliance outside Europe. So like how much spillover, a regulatory spillover effect we should observe in theory. So there are different reasons behind this. Cost of differentiation is already discussed, and there is cost of more stringent data protection, which could be different for different set of categories of firms, and expectation of future regulations, which will be different for different countries, the market size, the demand from consumers, so on and so forth. So all those factors will kind of determine, how large the spillover, regulatory spillover effects will be. And in the end, I was thinking, maybe it is possible to build a more kind of a structural type of model to bring together the empirics and theory and try to put a number, aggregate or average number about the global reach of GDPR, taking into account the different heterogeneous impact from different set of firms and accounting for the relative importance of those firms too. All right, now let me quickly talk about the second point, which is about the increasingly more fuzzy geographic boundaries in the digital world. So we know that both the supply side and the demand side of this privacy discussion can be quite mobile. From the perspective of the supply side, the website location is very difficult to determine. Is it based on server, headquarter, registration, tax residence, or there might be potential matching error in that. And from the audience location, with the usage of VPN, travels, and migration, this is also quite mobile. And more importantly, over time, we are seeing more and more usage of mobile apps when compared with websites. So both papers currently rely on websites, but I want to bring this kind of another big part of the picture, mobile apps, also into the picture. So if you look at this figure, which surveys the average daily time spent in the US on apps versus browser, you can see that 88% of the time nowadays are spent on apps, with only 12% spent on web browsers. And this is close to 4 hours per day spent on apps. So this is kind of a very important part of the picture too. And I just want to show you some also kind of aggregate trends in terms of how important the app market is. And this two pictures give you a sense of how large the market is in terms of quarterly downloads and cumulative downloads. So take Germany as an example. So here I put 4 different European countries: Germany, UK, France, and Italy. They are kind of quite similar in their trends. Take Germany as an example. Nowadays, you see quarterly downloads from both iOS and Android reaching over 500 million per quarter. And in terms of total cumulative downloads, which can be kind of considered as a proxy for usage, you have 15 billion in 2021, and with very steady growth over time. And in terms of the revenue, you see a quite similar picture. For Germany, you have $600 million being generated as revenue for the iOS and Android end per quarter, and total cumulative revenue have reached around $10 billion for this market. So overall, I want to say that this is a really important market. It's also a market with global footprint. So take YouTube as an example. You can see in those figures that YouTube is popular in all European countries, with a large portion of the downloads coming from Great Britain, Germany, France, and Italy. And in terms of revenue, you also see some nice global distribution. And what is more important here is that usually the app developers, they are using one single app for users in different markets. This is because the platform encourages one unified app in the back end. It's much easier to handle, and sometimes, most of the time actually, it implies uniform privacy disclosure too. So I take this 2 snapshots from the App Store from iOS. So this is for YouTube, and you can see that this is the app privacy disclosure for the US market, and this is the app disclosure privacy enable for the German market. And the data collection practice reported by the developer is actually the same, despite the language difference. They are all the same across different markets, and you can verify this for the other apps. It's always the same. So it seems that Apple only requires each app to submit one privacy nutrition label. So this data collection practices for different markets, which means almost, like you have to keep it consistent. This would suggest perfect regulatory spillover. So how should we, think about regulatory spillover in app setting, and how should we, handle privacy regulation for mobile apps? One thing that is clear is that we may face different regulatory and legal challenges here, because by definition, the app market is more mobile. Hence, you have more challenges to the location-based regulation. And one other thing that we should recognize is a key role played by platforms. So this is very different from the website market. In the app market, you have only basically iOS and Android platforms, and they effectively have the power of a global lawmaker, if you want to think about, their reach in different markets, and how to handle privacy for apps on each platform can be responses to competition among iOS and Android, and this will greatly determine the global kind of landscape of privacy regulation. And therefore, it will become very important to think about potential collaboration between lawmakers and platform to have, a better setting for the consumers. So normally I don't do this, but today I'm going to shamelessly just talk a little bit about my own work, because this is kind of related to what I was just talking about. So in this recent paper I have, we are using the Apple Store's introduction of privacy labels to think a little bit about both the supply and the demand of privacy labels. So the two papers presented today is more about the supply of privacy, the supply of different data protection to the consumers. And in this paper, we not only look at supply, but we also kind of try to estimate how consumers respond to privacy policy changes. So what is the kind of the demand side responses? So how to do that? In the paper, we use the policy of Apple to require all the app developers to disclose data connection in order to understand, what is consumers' response before and after this policy to the data connection practices. And we use a different setting. Essentially, the policy applies to only iOS apps, and we use the Android apps as a control group. And we study how the download and revenue are going to be changed before and after the policy change, and we also look at stock market reaction. So one key takeaway from the paper is that the consumers do seem to care a lot about the disclosure of privacy information to them, and they respond to that. So there is demand from the consumers for privacy, and those pictures kind of show you this pattern that before the policy change, you don't really have any effect, but afterwards, the consumers respond by reducing their downloads on the iOS end when there is more kind of information disclosure regarding to the privacy practices or the data connection practices from the developers. And this is important because the consumers are ultimately what the regulators care a lot about, and they want to make sure that, like any policy making can, make the consumers happy. So it's important to factor their concern for privacy into consideration when we are thinking about regulatory spillover, right? If different consumers in different countries care, privacy to different degrees, then the whole pros and cons of regulatory spillover should probably be reconsidered too. All right, so this is my discussion.
Thank you so much, Bo. We have our last discussant, Nicolas.
Yeah, thank you. And I will try and share my screen. So I'm going to try and stick within the 7 minutes that the organizer gave me, and that he didn't respect himself, but it's okay. It's always like this. Basically, I think, when you look at the two papers, they reach opposite conclusions, but as was said before by several speakers, including our speakers, there are ways in which the empirical analysis that they're proposing are not necessarily incompatible because they look at different things. So I'm not going to go very much into this, but what and I'm not going to go very much into the papers either. I'll be happy to forward my comments to the speakers. But what struck me the most is that although the methodologies are very different, they're looking at different types of privacy effects. What both papers underscore is that big tech, especially Amazon and Google in very different ways, somehow manages to pull off GDPR compliance without being hurt. That is to say, and it is most obvious in the Google case, Google complies the most with GDPR and yet manages to get its market share increase. So that, to me, was at least as interesting, and I'm speaking as a political scientist, it was at least as a political economist, it was at least as interesting as whether or not the Brussels effect is happening, which is a question that I understand is very important from a legal perspective. Now, it brings me to my main quarrel with these two papers, which is that they are mostly addressed to a legal literature, with maybe the exception of the coining the term Brussels effect, which was coined by political economist David Vogel in 1995, but they don't very much address a very interesting political science, political economy literature on privacy and transnational policy networks that has come since then, and that I think would be very interesting to consider from the perspective of each paper. So I'm going to do this very quickly in the time that is left to me, trying to bring what a political scientist would say on each of these two papers. So starting with the Frankenreiter paper, the paper that Jens presented, it seems to me that the EU seems like an exception to his argument that nations still matter very much to the way in which privacy regulation is cast. And my question is why? Is this because why is it that the EU nations seem to all just do away with their jurisdiction? I mean, that is an interesting question. It goes against one of your key arguments, which I think applies very well to the US policymakers, but not to the EU policymakers. Now, and I think it has to do with the fact that big tech is all American, and the EU is on the receiving end of what is coming from America. So I don't think these two can be separated very easily from a political science, political economy perspective. Now, again, from a political science, political economy perspective, some statements, as I said, mildly and maybe gently, appear as a little vague. For example, when you say that policymakers act on local preferences. Now, the standard response from a political scientist is, what does that mean? Whose preferences are you talking about? Are you talking about the preferences of big tech, or are you talking about the preferences of US citizens or consumers? Those are not necessarily the same. And I didn't say that your statement appears a little naive, but I could say that. That is what unkind political scientists would say on this. Ditto on the influence of domestic economic and political forces. Those forces are, and there is a literature in international relations, increasingly networked today. And I think that, on this, you would do well to bring in the political science literature that I mentioned, because I think it would enrich your frame and your perspective. What are these, what are these international networks trying to do? What are policymakers trying to do with respect to big tech? I think that is the kind of the underlying question to, in a sense, both papers. And it's a question that is not directly addressed, and I would like to see a little bit more directly addressed. It's the same thing on the paper that Stefan presented, which I shortened as PBPK 2021. I found the discussion in general in the paper very interesting, but especially the discussion of Google was very interesting. Google is increasing its market share, and that's unintended. So what can be said about that? Is there a Brussels effect forthcoming in antitrust? Is it already happening or not? Do we see, antitrust authorities in the EU slamming on the brakes when it comes to Google using its dominant market position to basically impose itself even more despite this GDPR regulation? What about the fact more generally that big tech are all American firms and that GDPR is an EU law? Does this matter for the finding of a Brussels effect, or is it irrelevant? I suspect it matters. That's kind of the underlying point that I'm trying to get at in this entire discussion. Same question on Jens' paper. What are US's and EU policymakers' different interests and position on all this? and how do they pursue them? This seems to be relevant. It's again in the background of both of the papers, but I would like it to be a little bit more on the in the foreground, because it seems that what is happening on in the markets and what is happening to consumers and to these effects is not independent of these background conditions. So I'll stop here. I think did I stay within my 7 minutes? I hope so. And we can hopefully the organizer will decide to extend the session by a few minutes so that the audience can respond as well and can step in.
Absolutely. Thank you so much, Nicolas, for your comments. Thank you, all the commentators. And indeed, I'm in the tricky situation, what to do now. And Nicolas, you're welcome to stop screen sharing. Yeah. And I would indeed want to take a couple of minutes, although I know we're already running over time, to ask more generally. I see that the Q&A questions have been answered while we were talking. So a quick question to the general audience. Are there people who have questions? So please do raise your hands now. For now, I'm not seeing them, but I'll leave you a couple of seconds, so to speak, to raise your hand if you have questions before I turn it over to Stefan and Jens to answer. So I have one question. No, not yet. While I'm waiting, one question from myself, and then I will turn it over to Stefan and Jens. So I was going along with Tobias's question on the temporary effects, and was asking myself that maybe, and there were a couple of questions in the Q&A which went in that direction also about the short-term and long-term effects. And is it possible that later on entities concerned realized that a lot of it might be an all bark, no bite situation, and then it became less interesting to adjust, be it the privacy policies, be it the third-party requests to what the GDPR required. And so would be maybe looking to risk of enforcement, like probability of risk of enforcement, and also sanctions, a variable which might be interesting to apply in this situation, and what are the possible implications for all the many EU regulations Stefan had listed on his last slide. So I still don't see questions from the audience. So I would suggest I turn it over to Stefan and then to Jens to react to both the discussants' comments. And if you want to say something more generally to the Q&A questions, which you've already answered, feel free. Thank you.
Jens, do you want to start or should I start? All right, I'll start. So first, thanks a lot. These were tons of helpful and very insightful comments, and thanks to all the commentators for carefully reading two papers and comparing them and so on. Lots of insights. I won't try to answer and address all the comments raised due to time limitations. I just want to pick a few. First on Katja Langenbucher's issue about short-term versus long-term. So I think there are two things happening here at the same time. So first, there are kind of long-term trends when it comes to the number of third-party trackers that you can observe that may be independent of the GDPR. I mean, websites just increasingly use third-party trackers, and then as Tobias also mentioned, there may be changes in the underlying technologies. Cookies may become less important, and so on. And so I think to some extent this is one of the shortcomings of these empirical studies. They cleanly identify only around a certain event, and so our event is the GDPR. Now, if something happens kind of 6 months later down the line, to what extent is there any causal impact? Who knows? So this is why I think empirically we have to be a bit careful. And even as I tried to indicate in my presentation, even around the event, we cannot formally, cleanly, causally identified. And so we, in various iterations of the paper, we have become more careful about making statements about long-term trends because, empirically, it's just challenging. I want to, basically pick from all the commentators perhaps one comment and say something about this. And I start in reverse order. Nicolas, these are great comments. Does it matter that big tech are all American firms and that GDPR is a EU regulation? Yes, it does matter. We are not directly tackling this in the paper, but in the background in the back of the mind, there is this notion like one of the reasons that the GDPR was created in the European Union was probably to tame kind of big tech US companies. That was one of the political motives. And now it's kind of interesting to see that because the compliance costs are so high, it appears that at least some US big tech companies have actually benefited from the GDPR. And so this is an interesting question, like what does this mean for regulation, that perhaps we're actually increasing the market share of some of these American companies, and do we have to take this into account when thinking about how to design these rules? And this applies, of course, not only to the GDPR but to all these regulations that I've listed before. Bo, I just wanted to, so thanks a lot. I fully agree with you when it's about reconciling these two papers. Ultimately, the question is, is the glass half full or half empty? And what is the normative standpoint to say, all right, this is a sign of the Brussels effect or not? And so currently, this is all about interpretation. And so we don't have a formal theory-driven background that enables us to answer that question. I fully agree with you. I also fully agree with you about the issues concerning geographic location, determining the app space is a super interesting space, which it's harder to get some of the data, which explains why lots of these studies are still going on in the browser market. And Tobias, you raised lots of interesting things. Just one comment about what is the economic significance about this. And so I think to some extent we can tell the story like before this there were kind of 15 third-party requests per website, and after the GDPR this has decreased by about 0.5 third-party requests per website. And you may find this large or low. We think it's actually not that small if you take into in the non-EU cell, if you take into account that this is a global impact on the websites we are looking at. But of course, is this kind of a convincing story? Does this have economic significance? And I think the honest answer is, we're basically only measuring the number of trackers. And so this came also up in the comment, like, ideally you would like to know something about purpose, about data flows, about categorizations, and all this data we are basically currently not using. And I would argue, on this large scale, it's basically not available. There are some CS papers that basically try to get at all this. They use machine learning models to interpret what the purpose of the cookie is. And, in a few years, this kind of research may flow into kind of empirical legal studies, but we're far from that stage of the research. Thanks.
Thank you so much, Stefan. I could go on and on and on, but and I will now turn it over to Jens, because it's really fascinating and really interesting, and also, thinking forward about what the implications are indeed for the next step in regulation. Jens.
Yeah, thank you so much. I can just echo Stefan's thanks for your comments. I think these were all great comments, and I would love to continue today. And I hope that we'll continue this discussion offline after this event ends. I'm also going to pick out 3 questions, not because the other questions were relevant, just because I cannot possibly talk about all the great points you mentioned. I'm going to go in the order in which the comments were made. I'm going to start with a point that Tobias made. The question one question that you raised, Tobias, was basically like, when Google and Facebook comply, does that mean that it matters that much what all the other firms are doing? I think this is a great point. And in a way, I think my analysis actually shows that the biggest firms in the sample seem to have shifted their regime towards a globally GDPR compliant regime. But I think the question, which mechanism is at play here, still matters. And the reason for that is that if it's cost-based effects that make Google and Facebook comply with the GDPR globally, Every time an EU regulator goes after them and forces them to change their data practices, they automatically start treating everyone around the globe the same way. If what's really happening is some kind of like a sales pitch, they might still have the technical possibilities to treat US consumers and EU consumers differently. And in the case of Facebook, this is actually something that we know happened. After they shifted to the GDPR, they still had different defaults for US and EU consumers. That was one of the reasons why the FTC came after them and why they had to agree to this 5 billion settlement. So I think ultimately the mechanism still matters. But it's a great point, of course. Regarding Bo's question, I had a very similar reaction to your comments than Stefan, so I will not talk a lot about that. In the end, I think it's super important to acknowledge that I also find that there are extraterritorial effects. This is not what I'm focusing on in my paper, because I'm really mostly interested in the differences between the common accounts that you usually find in the literature and what I see in the data. But of course, my paper also shows that the GDPR did affect companies beyond the European Union. And this is an important takeaway from my paper as well, although I don't really focus on it that much. Nicolas, your question regarding network regulators, I think is a great one. And I think this is a super important point that is very important for the general situation that we're talking about. And I would love to continue the discussion. My thinking in the paper is that it's basically a conscious decision not to focus too much on what the regulators are doing. And the reason for that is that I'm mostly interested in these direct unilateral effects. So in a way, the question that I'm trying to ask is, does it even matter that much what the local regulators are doing? Or are we living in the world where if the EU doesn't succeed in convincing lawmakers, regulators elsewhere to adopt a similar standard through the various networks and through the various international mechanisms that they are, of course, a part of, does that even matter? Can the EU just unilaterally push ahead, implement their standards? And all the companies that act in more than one jurisdiction are going to fall in line internationally. But I'm not a political scientist, so there might be a lot that I could do better, and I would be super grateful if we could continue this discussion after this event, because I think there's a lot that I can learn from these comments and try to improve to make sure that there's no friction that is too obvious between what I'm doing in my paper and other parts of the literature that are, of course, super important for this general discussion. Thank you so much for all these comments and also for the questions in the chat. I think this was super, super helpful, and I really appreciate the feedback and you just engaging with my work.
Well, thank you so much again, both Stefan and Jens. Sorry, it was really inspiring, as Tobias says in the chat. I personally learned a lot, both from the papers and also from the comments of the discussants and from the Q&A questions. And as you said, Jens, it would be really nice to take this not only offline, but also in person. So I know you're kind of stuck due to visa issues in the US right now, which is maybe not even the worst place to be stuck. But I really hope we can indeed move it sort of together around an actually existing table in the actual world pretty soon. With Stefan, it's going to be easier to take a train, and at some point maybe Jens will be able to as well. So thank you so much for this. It was really interesting, fun, and as I said, I learned a lot, and I hope to see you back in one or the other format really, really soon. Thank you so much.
Thanks a lot.
Bye-bye.
Thank you very much.
Bye-bye.